Divorce Mediation for Entrepreneurs, Dividing the Business Without Destroying It. A guide. Divorce for entrepreneurs is more than a personal crisis. It's a crossroads where the future of a company, employees, and years of effort hang in the balance. Dissolving a marriage while running a business forces founders to guard their life's work from the turbulence of litigation. New York law offers a roadmap for dividing marital property and valuing businesses, but mistakes can jeopardize control over the enterprise. The decisions you make today will shape whether the business emerges intact or suffers harm. New York's Equitable distribution law guides courts when dividing marital property. A judge aims for fairness, not necessarily an equal split, and considers factors such as each spouse's contribution to the marriage, separate property claims, and future financial circumstances. Businesses created during the marriage are considered marital property, and increases in the value of a premarital business attributable to the owner's efforts become marital property. A spouse can claim a share of that growth even if they never came to the office, because state law treats a business as a marital asset. An experienced attorney can help you classify assets and argue for or against distribution. Litigation can be destructive. A contested divorce invites public disclosure of company finances, drains resources with attorneys' fees, and undermines morale. Judges may order interim management changes or even force a sale. Most importantly, you surrender control of the outcome to a court with a heavy docket and limited time to understand your business. For entrepreneurs seeking certainty and confidentiality, mediation offers a strategic alternative. It allows spouses to craft mutually acceptable solutions, maintain privacy, and preserve the company's operational stability. Through mediation, both sides can hire a neutral valuation expert to assess the business. Valuation methods include the market approach, which compares similar companies, the income approach, which projects future earnings, and the asset-based method, which values tangible and intangible assets. The mediator helps the parties agree on a standard, so there's no fight over competing valuations. Once the value is clear, there are several options for dividing it. One spouse may buy out the other's interest with a lump sum or equivalent assets such as the marital home or retirement accounts to avoid taking cash from the business. Structured payments over several years with interest can spread the cost and keep cash flow steady. Co-ownership is sometimes feasible, but requires a detailed agreement on roles, voting rights, and a future exit plan. Innovative equity arrangements let the non-operating spouse receive dividends or a share of sale proceeds while maintaining control. If you and your spouse choose mediation, maintain accurate financial records and gather documents like tax returns, financial statements, partnership agreements, and any prenup. These will help the mediator understand the business and expedite negotiations. Remember that your business is not just a number, it's a livelihood for employees and a legacy you've built. Mediation allows creative solutions, such as limiting an ex-spouse's involvement in management, establishing a voting trust, or structuring a phased buyout. Those options are rarely available in court. A lawyer familiar with business valuation and divorce law can help you explore them and protect your rights. Divorce is a pivotal moment for a business. While it may feel easier to let a judge decide, that choice can lead to a forced sale, lost goodwill, and prolonged conflict. Mediation offers privacy, flexibility, and control while preserving operational health. Juan Luciano divorce lawyer guides business owners through divorce with strategic planning and tailored solutions. The law firm's office is at 347 Fifth Avenue Suite 1003, New York, New York 10016, and their phone number is 212-537-5859.